this will necessarily be a fairly whistle-stop tour of the recent case law last 6 months or so. Please don't worry about noting them down. I'm not going to give you the citations. Instead, if you contact me directly by email or the clerks, then of course we'll provide you with the notes that I'm working from, and so you'll have all of the citations that you need. My email is do@5pb.co.uk. I'll remind you of that at the end. We'll start then with some procedural matters, move on to some evidence, and finally some sentencing cases. The first one relates to perverting the course of justice. It's a case of RR from last year, and really the inadequacy of a direction that was given. In one of those cases where on the first 2 counts, the appellant was facing allegations of rape, and in the final count, that of perverting the course of justice. Count 3 related to the fact that following his release on bail, he made contact with various members of the complainant's family, work colleagues, in order to have pressure placed upon her to withdraw her complaint. And so we had 2 quite perceptive questions from the jury, who were clearly concerned about counts 1 and 2, and their questions were perfectly sensible. Sadly, they didn't elicit a sensible response. The questions were these: can we ask if the decision on the first 2 counts, i.e. the counts of rape, will impact on the decision of the third? And secondly, could you be found guilty of perverting the course of justice based on a charge that you might not be guilty of? A great question from the jury. Unfortunately, the answer to the first question was given no, and the answer to the second question was given yes, without any further assistance being provided to the jury at all. It was argued that the judge's direction amounted to a misstatement of the offence. The Court of Appeal agreed with that when the appellant argued that the jury should have been directed that if he genuinely believed that the rape allegations were false, then the jury should consider the propriety of the means adopted to meet his end. Now, that is not to say that if the appellant had been acquitted on counts 1 and 2, he was bound to be acquitted on count 3. That's not the position in law at all. But the jury were entitled to a rather better explanation of the law than they got, and as a result, the conviction was quashed. So that's the case of RR. I move on to an adjournment for telephone evidence. This is the sort of thing that might well crop up in your cases. It was one of those where a sexual offence had been charged, telephone messages had been deleted by the complainant, and at trial the defence applied for an adjournment, possibly for many months, so that missing messages could be obtained. The problem was that they were on a platform in America. It was going to take very many months to obtain them. And the Court of Appeal confirmed that the judge had been right to refuse that adjournment. The conduct between the 2 of them had not occurred in the middle of a relationship when phone evidence might be of more relevance. And so what was required from the judge was a careful balancing of whether the evidence was likely to assist in the case at all. There was no evidence in that particular case that any messages that might have existed would have assisted anybody in the case. That was the case of McPartland and Grant, again from last year. So again, you'll get the citation if you obtain the notes at the end of the webinar. I move on now to the case of PR, which is an abuse of process case. Again, allegations of sexual impropriety. This was one where the initial allegation was made in 2002. For whatever reason, it was not pursued, but it was pursued again in 2016. The complaint was resurrected, by which time the paper file from 2002 had been lost, or rather destroyed, in a flood. That led to an abuse application by the defence, but this continues a line of cases which have slowly but surely begun to close down abuse of process arguments in cases where evidence has been lost. It was said here that a substantial amount of the additional material that could have been used to test the reliability and credibility of the complainant. So in other words, the trial process was sufficient to ensure that a fair trial could take place, and there was no need for a stay in that particular case. I move on then to the case of Lewis, again from the end of last year. This case involved inconsistent verdicts, but perhaps more interestingly, whether or not a route to verdict was mandatory. In respect of the inconsistent verdicts, the defendant was convicted on one count of anal rape. The jury were unable to reach verdicts on counts 2 and 3, which were similar in nature. And the Court of Appeal reminded everybody of the leading inconsistent verdicts, that of Formals from 2013. Essentially, it's a very heavy burden for the defence to discharge, and so it's going to be difficult to run an appeal on the basis of inconsistent verdicts ordinarily. But more importantly, or more interestingly, was whether or not the steps to verdict by the judge are something which a jury is required to follow as a matter of law. Are they mandatory or are they not? The Court of Appeal said no, they're not really. That's just a matter of semantics. The judge will explain the elements of the offence, and all of the other directions, of course, are mandatory, but not the steps to verdict. They are an approach that the jury can take to the case. You'll find, though, there's some criticism of this particular ruling, because in many cases, judges, when they deliver their summing up, combine a steps to verdict with an explanation of the elements of the offence, and because those two things are intertwined. So I'm not surprised that the conviction was not quashed, but at the same time, a little bit of caution with that. I think that if a judge gives route to verdict, by and large, you would expect the jury to follow that reasoning. Move on now to the case of Rasheed and Sherman from the end of last year again. This related to expert evidence on gang membership. This will become, I guess, increasingly important with county lines cases. The judge had a voir dire in this particular case and concluded that the officer had all of the qualifications of an expert, and that fairness in the trial could be attained by cross-examination of him, using whatever material was available. The appeal was dismissed, but in that particular case, the judge was criticised for failing to focus sufficiently on the relevance of that evidence and failing to discuss his directions with counsel in advance. There was apparently a delay of several days between the close of the evidence and the summing up. He failed to give a split summing up with directions on law before the speeches, failing to provide written directions on law, and failing to provide a route to verdict at the start of the summing up. And so you can see there the Court of Appeal increasingly expecting judges to adopt the modern way of doing things. Split summing it up where it's appropriate, written summing up for jurors to retire with. They want that kind of good practice set out more frequently. Defences then, in the case of N from the end of last year, defences under the Modern Slavery Act. The appellant in this case pleaded guilty to cultivating cannabis, and in the course of mitigation, it was submitted on his behalf that he was effectively a victim of modern slavery. Nobody spotted this, not defence counsel, not prosecuting counsel, and not the judge either. Eventually, it came before the Court of Appeal, who quashed the conviction, and that case serves as a reminder of all concerned that you need to bear in mind that defence that exists under Section 45 of the Modern Slavery Act. Well worth a read, that one. Move on swiftly to the case of LeBrock, end of last year. Now, ostensibly, LeBrock was a case involving counsel getting a wasted costs order. No doubt he and the judge fell out rather badly towards the end, not least because in the course of his closing speech to the jury, he spent quite a lot complaining about the Section 28 system and ground rules hearing generally. So, in other words, cross-examination of complainants well in advance of the trial. and essentially complaining about the sort of measures that Teresa was speaking about a moment ago. Secondly, he began to talk about the previous sexual behaviour of the complainant, in contrary to an earlier ruling that had been made under Section 41. Both of these things made the judge very cross. He discharged the jury and issued a wasted costs order. I should tell you that the Court of Appeal overturned that, quashed the wasted costs order, and noted, in fact, that the evidence in the case had moved on since the ruling. In the course of re-examination, prosecuting counsel had reintroduced evidence of previous sexual behaviour, and the defence advocate was doing no more than referring to what the prosecution themselves had led. So not a common problem. The big takeaway from that really is that you need to be very careful before you start criticising the sorts of measures that are in place for vulnerable witnesses in the course of a closing speech. I shall certainly do my best not to repeat that, having done it last year. We move on now to the case of Chauhan and Croft, end of last year. That is to do with the timing and adequacy of rulings, in this case on a no case submission. As we know, judges will sometimes announce their ruling, say which way they're leaning, and will reserve the full ruling for a later stage. Most of the time that's not a problem, but in this case it was, because the judge's ruling impacted upon the way in which the defence then wanted to present their case during the latter stages of the trial. And the Court of Appeal said, of course, the judge can reserve the ruling, but it should be given promptly, and it should certainly be given if either side require it. Of course, if you've brought this case to the attention of your judge, you've no doubt fallen out with them, but you will nevertheless have to bear that case in mind if you get that kind of problem with your judge. Case of Allen now, 2019. This case involved a judge continuing without a jury in circumstances where there had been witness tampering. It was established that in fact it was nothing to do with the defendant, although that's normally quite difficult to establish. The decision whether to continue without a jury is not dependent upon whether it was the defendant's fault. Quite often it will not be possible to prove that the defendant had anything to do with it. So it's not necessary to determine that the defendant is involved in the tampering. Having been satisfied to the criminal standard that jury tampering had taken place, the question for the judge then was whether it was in the interest of justice to terminate the trial. If so, that must be done. But if not, would it be fair to the defendant to proceed without a jury? If it is fair, then the jury has a discretion to continue alone without a jury. Bear that one in mind, because you're going to have a tricky conversation with your client down in the cells, I suspect, if they've had absolutely nothing to do with the jury tampering, but it has nevertheless taken place. Case of Graham, 2019, is to do with the receipt of prosecution evidence after the close of the prosecution case. This really restates earlier authorities. The judge has a discretion to allow prosecution evidence to be admitted after the close of the prosecution's case, but it has to be done with care and caution, and nothing must be done to encourage the belief that sloppy police practice can be overcome by the late admission of evidence. There is a general rule that prosecution evidence should be admitted into evidence before the end of their case. It will sometimes be the case that something that they didn't realise was relevant becomes relevant during the course of cross-examination, or it's realised rather too late, or perhaps when the defendant's giving their evidence. Those things will be perfectly acceptable, but if the prosecution have simply failed to look at the material they have properly, it may well be that a judge will decide that it would not be fair to admit it after the close of their case. Case now of Bridge, very unfortunate case this one. It's to do with the racial composition of juries. Defence counsel, in the course of his closing speech, made a rather ill-judged remark the defendant, being the only black person in the courtroom, asked the jury to consider how they would feel, being the only white person, if everybody else in the courtroom, all the jurors, the counsel and the judge were black. Well, the jury took a rather dim view of that remark, as you might imagine, and the judge noticed it and then spent some time explaining to the jury in the course of his summing up that it was perhaps a loose remark, that they should ignore it, put it to one side when considering their verdicts. The appellant appealed, but unsuccessfully. The Court of Appeal referred to an old case of Ford from '89, which said that the racial composition of a randomly selected jury cannot provide the basis for a judge to discharge jurors or the jury in an attempt to secure a jury with a different racial composition, as you might expect. So it doesn't provide a ground of appeal, but it just goes to show the sort of disaster you can have with a closing speech if you make that kind of remark. A disastrous summing up, though, in the case of Bowden, from again the end of last year. It was to do with separate verdicts. Get this, the judge said this about the various verdicts: technically you are supposed to come back with separate verdicts, as it were, but frankly this is one of those cases where it stands and falls together. There is really no separation, as it were, between the three counts that you've got, the separation of what they actually are, because in reality there isn't any separation. He then went on to talk about the indictment as being rather complicated verbiage, all that massive language, and the only help that he provided to the jury at the end was that it could all be boiled down to one word: fraud. Not surprisingly, the Court of Appeal thought that that wasn't terribly helpful, and that conviction was quashed. Watch out for that. The Court of Appeal, if the judge has made a real Horlicks of it in that fashion, you are going to have to put the judge right straight away, I would have thought. But if it ends up in the Court of Appeal, there are grounds there for it. Case of Thomas, a useful guide to an intermediary. Obviously, they're absolutely essential if they're for a prosecution witness, less so if they're for a defendant, it would seem. Every sensible step is to be taken to identify an intermediary, but if that's been successful, the next step is not apparently to stay the proceedings. Instead, the judge needs to make an informed assessment of whether the absence of an intermediary would make the proposed trial unfair. Now, let me just move on to Reynolds Guidance here on summing up. It's obviously one in which many complaints were made about it in the Court of Appeal. It's a case of Reynolds. Really, it's of more value to those who sit, I would suggest. So I'll skate over that. But in short, counsel's speeches are no substitute for a judge's impartial review of facts. And they concluded in this case with some comments about what judges say in the course of their summing up. There is no all-embracing rule, but the judge's personal view must be considered carefully before being expressed. And it's not enough to round on the defendant and then say to the jury, it is entirely a matter for you. So obviously the trial judge in that case somewhat slapped down. We've all had judges that have done that kind of thing. I'm about to move on to evidence. I will give you one or two cases from here. I'm conscious of the fact that we are overrunning, so I'll do one more case. The remainder will be in the handout if you would like them. So one more. It's a case of Dania. I think one or two of you might know about it. It was, I think, tried in front of Her Honour Judge Williams down in Maidstone, multi-handed murder case, and it concerned the duty or otherwise of the prosecution placing a witness before the court, and then the judge's approach to a witness summons. It was one where the defence applied for a witness summons for a particular witness, and it was said by the Court of Appeal that the judge should be careful not to trespass into the territory of the jury by forming his or her own view of the credibility of the witness. Nonetheless, Section 2 of the Criminal Procedure Attendance of Witnesses Act 1965 requires the judge, first of all, to consider whether a witness is likely to be able to give material evidence, and secondly, whether it is in the interests of justice to compel their attendance. Section 4, in relation to the issue of the warrant, requires consideration whether the witness is likely to be able to give material evidence. Although that section does not itself refer to the interests of justice, it is premised on the prior issue of a summons, which does require it. I know that that was a somewhat controversial decision at trial, but no great surprise that the conviction was upheld in the Court of Appeal. There are more cases that we have on the fact sheet, but I think I'll leave it there because we're already quarter of an hour over our allotted time. So thank you very much. And if you want to contact me directly, it's do@5pb.co.uk. Thank you.
David, thank you very much indeed. We have received 3 questions, the first 2 of which are for Robert O'Sullivan. So I will ask those questions now of Robert. Robert, the first of those questions is from James Bancroft, and it's this: would or will having already recovered from coronavirus be considered grounds for not being considered infectious for the purposes of the Act?
Hello, James. That's a very good question, and I think the answer is we don't know. Certainly the Act doesn't say anything. I'm not sure the science is entirely clear at the moment, although it tends to suggest there is immunity once you've had the virus and recovered. But if we look at the slide, we can see that the test for potentially infectious is there a risk that the person might infect or contaminate others? Well, if you were in a branch of Safeways or Waitrose, as apparently somebody was this morning, and you went round licking the door handles and shouting, "I've got the virus," then probably that would be grounds to take that person away. Not arrest them, of course, at that stage, because there wouldn't be a power of arrest. But if that person then refuses, then it could be a ground of arrest in due course, but they'd certainly need to be tested.
Thank you very much. And Robert, the second question from Samuel March is this: the test seems to be is or may be infected, but might not we all be infected at this point? Isn't most of London an infected area, given that it's tipped to potentially be the next epicenter of the pandemic?
I think the answer to that one is in little b on the slide. It's a reference to the infected area which you were referring to, but that is further defined in Schedule 21, and in brief, an infected area in fact is not in this country. An infected area is an overseas territory where there is thought to be a risk of human to human transmission. That's the point about people coming in to airports and whether they're being tested or not. So I'm sure you're right that London may well be an infected area, but it wouldn't be as defined under the Act.
Thank you very much indeed. The next and final question is for Dominic. Dominic, Barry asks, is there any indication in the regulations as to the time limit per period of exercise, whether an hour or 2 or more?
The short answer is there's no indication as to time limit, certainly no express indication. But again, you come back to that word need, because it's a reasonable excuse for you to leave the house if you need to do so for the purpose of exercise. And so certain people are likely to need rather longer to exercise than others. You think of elite athletes who can spend a long time training. Equally, they may have facilities at home. Do they need to leave the house at all in terms of exercise? But the touchstone is always going to be the word need. And the only other thing to say about that is, of course, it brings us back to the question of what happens if you leave with a reasonable excuse, but stay out for an awful lot longer than that reasonable excuse would have permitted you to be out for. There doesn't appear to be any requirement that you return home as soon as your need has been fulfilled, and that may be a lacuna in the Act. Certainly there's what we should do on public health grounds, which is leave the home for as short a time and as infrequently as possible, but the Act doesn't in fact prescribe maximum periods for exercise, no.
Thank you very much indeed. Well, thank you to everyone for joining us. This is the first of what we hope will be a number of these sessions over the next few weeks. We expect the next talk will be at 3 o'clock next Wednesday, and we very much hope you'll be able to join us then too. Until then, thank you very much indeed for joining us, and we all hope you have a very good Easter weekend.